Aloha, this is Professor Porter. We're talking about the Federal Rules of Evidence. Today we're covering Article 9, specifically authentication, and Rule 1901 under Article 9, which is authenticating and identifying evidence. I really wish they almost kept the rule at identifying evidence. I think authenticating sometimes complicates it for people learning evidence, but really, if you think about this, it's like if you're going to introduce something into trial, most oftentimes it's an exhibit, a document. Uh, there's some rules that specifically relate to handwriting or a voice, identifying someone's handwriting, identifying someone's voice, almost always over the phone. Really, what we're doing is we're trying to say that it is what the proponent purports it to be, what the proponent says it is. So just note at the front end that what is the proponent saying this evidence is? Are they saying this is just a photograph of a dog? Or is this the photograph of their dog that they've had for 8 years? Or is this the photograph of their dog on a certain day that was related to an incident or event? Authentication is how does it connect to what they want it to be, to what they purport it to be? And that's all authentication is. And if you think about it, the easiest way this is cured and satisfied at trial, and why trial attorneys don't spend a lot of time on authentication rules is it's most oftentimes a witness with knowledge. A witness with knowledge establishes authentication of an exhibit, of some handwriting, of someone's voice. Here's the rule and what it says, and essentially, 901A is the general rule, is the standard rule. To satisfy the requirement of authenticating or identifying evidence, must produce evidence sufficient to support that the item is what proponent claims it is, right? So that's it. And if you think about that, it can then be witnessed with witness testimony. You call a witness with knowledge to say, yes, that is my car, and it does look as it looked on the date in question. So you're calling a witness with knowledge to say that that item, that photograph of a car, is what the proponent claims it is. One of the ways I think about remembering this rule is one of my many Dinero principles, right? If you could just picture Dinero as it relates to authentication, as it relates to this rule under the Federal Rules of Evidence, just saying it is what it is, right? It is what it is. You have to establish, as the proponent of evidence, that it is what it is. You have to establish that is authentic, that you've identified the evidence, and the most obvious way is through witness testimony. 901B goes into some of the examples of how one can authenticate evidence. So think about this photograph right here. I live in Hawaii. This is Matsumoto's, which is a famous shave ice place on the North Shore. And if you're ever in on Oahu, you should go to this place. But I've been to this establishment many times, so therefore I could authenticate this photo. This is a photo of the front street-facing side of Matsumoto's, and there is often a line pouring out the door like that. But imagine maybe something else is at issue in the lawsuit. Maybe is this Matsumoto's as it looked on the day in question of some event or some incident, right? So what is the proponent want it for? What are they introducing it for? I could introduce it for the general stuff, or maybe if I was there on a particular day, I can authenticate this as a photograph that depicts the store on a particular day, or show something in particular in this photo related to the people in line. So it is always pay close attention. Does it do what the proponent wants it to do? It is what it is, to remember our Dinero principle. Here's B, some of the examples. There's two that I think are really worth highlighting because this is how most of it happens. B1 is like I say, it's a healthy percentage of the time when you're authenticating something, you're just talking to it, taking the testimony of a witness with knowledge. That is, someone comes in and says, I recognize that photo. I recognize that piece of real evidence, that hammer. I know what that is, right? I am a witness with knowledge. All witnesses have to have personal knowledge about which they talk about. That's a different rule of evidence under Article 6, Rule 602. But here we're able to establish authentication. We're able to authenticate evidence by having a witness with knowledge of what that is. So that's why we call certain witnesses. That's why witnesses, quote unquote, sponsor evidence. They are the ones, they testify, a witness with knowledge. Now imagine someone that I create lots of PowerPoints, for instance, as a teacher. I create lots of different media accounts, and let's just say there's hundreds of them. So if you put a particular PowerPoint in front of me, I may not have knowledge like, oh yeah, that's mine, or oh yeah, I remember creating it. So I might not be the witness with knowledge of the specifics of what you want me to authenticate, but maybe I can testify as to distinctive characteristics, and that's the example under B4. I can look at the appearance, I can look at the contents, I can look at the substance, I can look at the patterns or other characteristics, and I can say, taken all together, this is one of mine because I use the same type of background. I usually put some copyright information in the bottom left corner. I know the video of me in the bottom right corner would obviously be super distinctive as far as a characteristic, but I can look at something that maybe I've written or maybe that I've created in the past and say, yeah, I don't have specific knowledge, but I can testify to its distinct characteristics. And you could think about that. I could authenticate something. I could authenticate an exhibit, maybe even if I didn't create it, just because I have familiarity with those characteristics. So think about law enforcement officers that are regularly evidence techs that are regularly collecting evidence and putting them in bags and having initials on them and doing things like, yeah, I don't remember the specific one, but this packaging has the distinct characteristics of something that I collected as part of my job. And here's a handwritten note. Yeah, I don't remember that as Uncle Jerry's notes. I don't remember the specific note, but I know I've seen enough of his writing and enough of his notes that I kind of recognize the distinctive paragraphs of the characteristics of the handwriting. He was a doodler, so he always did drawings like this next to it. So I recognize this as having the distinctive characteristics and that might be sufficient enough under B4 to authenticate this note and to show that it is in fact a writing of Uncle Jerry. Next, the other one that's worth thinking of, and sometimes this is an area ripe for testing, there's examples that have to do with handwriting, and there's examples that have to do with voice, and essentially identifying someone, some relevant comparison of handwriting in the case. Now, most of the time, handwriting is a whole area of expertise. It's fraught with some problems. There's lots of literature out there about its problems, but most of the time people are calling expert witnesses to talk about handwriting, a handwriting expert, and that's B3. It can also be put before the trier of fact, so it could be the jury's asked to compare, two writings to say. Or the last one is you can actually just ask someone who's familiar with the writing. So you could ask someone's daughter to say, you can't authenticate this note, but can you authenticate the handwriting based on your familiarity with it? And notice the red language in B2. It's not acquired for current litigation. So it's not like we can call someone a paralegal in the case and say, study this person's handwriting, and then we'll call you as a witness at trial. No, it's going to have someone that has independent familiarity, a relative, someone who's worked with someone else, someone who's an opportunity to see their handwriting somewhere independent. And just notice the distinction with B5 when you're talking about someone's voice. And this might be important for anything that's some kind of phone call or a voice message or something where you're hearing someone's voice, maybe identified by a voice over PowerPoint like I'm doing. They can do it based on any purpose. You actually can develop familiarity in the current litigation. If you think about B5, the real reason is for government witnesses, agents who are listening to wiretap evidence. They are listening, they can gather context, and they can identify someone's voice because they've listened to it in the course of this case. So other examples having to do with handwriting and voice, but don't lose sight of the healthy percentage of them are just a testimony with a personal witness to say, Dinero style, it is what it is. That is the hammer. That is the real exhibit in this case that was used in this case. That is the document, the lease, and I'm familiar with it. I have personal knowledge of it, so I'm a witness that's going to testify about it. And think about, sure, there can be a witness that testifies, but there can also be some type of certificate that's put before the court. Think about a business record, some accounting records from a prior year for a company. If we subpoena those accounting records, it's going to come with a certificate on top from someone that's called a custodian of record. And they're going to talk about why it's a business record under hearsay rules and a hearsay exception of 8036. But they'll also devote a couple sentences of that certification that they'll sign and seal. They'll devote a couple sentences to say, I am a person with knowledge and that these are what they are. These are the accounting records for the year in question for this company. So they'll give a certification that'll essentially speak to authentication and hearsay such that the accounting records can come into evidence. The court can, of course, consider that certification, even though the certification doesn't go before the jury. The certification isn't admitted evidence. The court can consider it as a preliminary determination under 104A. Look at the certification from the custodian of records, not have to hear otherwise for the custodian of records, and it can admit without more those documents into evidence because it satisfies Article 9 and authentication rules, and it satisfies hearsay in Article 8, including the business records exception.